Thank you, Madam Chairman, and thank you to the witnesses. I found your testimony so far to be very forthright and helpful. I will just say that families coming to the United States seeking refuge and asylum expected to be met with an American welcome, I think in the style that Mr. Mullen might have wanted, but this administration chose to go against decades of immigration policies that kept families together and court rulings that established protections for migrant children. And when we talk about separating kids for cause, it's because it's for cause in those individual circumstances where there's evidence suggests that that would be the right thing for the child. It wasn't this wholesale separation that took place under the Trump administration. I think that's what's new, and that's what concerns a lot of members of this committee. As a San Diegan, I know the border is part of our identity and our culture, and San Diego, Tijuana are inextricably linked. The border we see as an opportunity, not as a threat. And ripping terrified children from their parents' arms is not the policy of neighbors. We must acknowledge the lasting trauma that these children may face for the rest of their lives. It's horrific to know that our government caused this pain, and we as a Congress have a duty to provide support and resources to assist separated families. I do want to acknowledge that the work of the court system as an institution that's stepped in and made a difference here, partly because it was the court in my home district, Southern District of California. It was Judge Sabraw, who I actually practiced law with a long time ago, and he's one of many federal judges. He happened to be a Republican appointee who takes his job of providing justice very seriously in an impartial and non-political way. Commander White, in a recent court filing, you stated that statistics suggest that if a separated child who ORR discharged before June 26, 2018 remains in the United States, then he or she is, quote, probably with their family. And considering what we know about the challenges HHS has faced in identifying separated children, what level of confidence do you have that these separated children were placed with their family?
Thank you, sir. So let me clarify this. While we do not know, because it was never provided to us in HHS, while we do not have a list of every kid who is referred to us as separated, we absolutely do know to whom we have discharged every child who's been in our care. So when we speak about those children who were separated and referred to us and appropriately discharged before Judge Sabraw's decision on the 26th of June, we can speak with certainty about what happens to children in that process. So the answer, and I alluded to statistics earlier, is during that year, 86% of children in our care went to an individual sponsor. 90% of the time, that's to a parent, sister, brother, aunt, uncle, or grandparent. And the remaining 10 to 11% of the time, it's to a cousin or other distant relative or a family friend. So while I don't know which of the kids were separated, because I haven't been given that list, I do know what happens to children who exit ORR care. And indeed, if someone cared to give us that list, we could walk through it. But that is the answer to that question. It's why I said probably they're with family members, because that is to whom we discharge the vast majority of children.
Okay. And in your recent court filing, you stated that you believed ORR would face significant hurdles if it tried to collect information from separated children who were discharged before June 26th.
Yes, sir.
And that you believe that attempting to reunify them with separated parents would present, quote, grave child welfare concerns. Can you explain why you think that that would be a grave concern?
Yes, sir. I think it's helpful if you look at the whole paragraph in the declaration. So here's what I said about grave child welfare concerns. And what I said was that in some instances, the sponsor, that family member, might not wish to have the child, or the child might not wish to come back into federal custody so we could go through this legal process. And since in ORR, there is no capacity to go and take children into custody, what would that actually look like? And I really want this understood. What that would actually look like is ICE agents or other federal law enforcement going into an immigrant family's home to forcibly remove that child and put them back in federal custody. So yes, I believe that has a very significant risk of re-traumatizing a child who's already been traumatized in many cases by separation, and I stand behind the truth of what I said in that declaration. That's not how it's appeared in the papers, but that's what I said.
Okay. But you do agree that we should try to determine where the children went, who they're separated from, make sure their parents and guardians know where they are?
I think we are eager to comply, as we have thus far, with whatever Judge Sabraw determines that we need to do. And I think it's very important that people know the full story, but I want to be clear. We will not have at our disposal the same tools to identify children in care, nor will have the same capacity for children who are no longer in care. It's just a completely different ballgame.
All right. Thank you. I'll yield back.